I'm Gary Harper.
And I'm Susan Campbell.
I had a little problem getting started there, but, we were talking earlier about your kids,
Yeah.
and I was just, my jaw dropped when you said they went back to school in July.
I know.
That is, what is going on?
It's the modified year-round schedule. So my kiddo started first grade July 22nd.
July. I mean, that is half the summer. That is nuts.
Trust me, I know. The month of August to me is the best month of the whole year.
Yeah.
I love vacationing in August. It's the best time.
Right.
Everybody's kind of settled into the summer and super relaxed.
Yeah.
No more. We're back in school.
If I'm not mistaken, I thought maybe years and years ago, school started after Labor Day.
Yeah, well, that's like the farm schedule. Midwest kind of,
okay.
Yeah, that's kind of the, like, everybody has, the county farm, Labor Day weekend, and then you go back.
I'm not a farmer, didn't grow up on a farm, but I think I went after Labor Day. But anyway, the reason I bring that up is you do have kiddos, and we're talking about wills and trusts today. Are you up to speed with your wills and trusts? No?
So, gosh, you're putting me on the spot and you're going to embarrass me in front of our guest.
No.
I'm not. We've had important conversations with the people who will be entrusted to handle this, but it's not in writing officially anywhere. And I know we need to make that happen.
Listen,
it is one of those things, though. It's hard to think about. And I know that there's the logic and the emotion, and you got to take the emotion out of it. But sometimes it's kind of hard to do.
Yeah. Well, as they say, life gets in the way, and, you got other things to do, and you have to make time to just, schedule it and make it happen. And I didn't mean to bring that up to beat you up.
Okay.
So, but
it's
it is a nice little,
I'm on the spot. I've got some homework.
A little gentle reminder, if you will. Listen, we have a lot to discuss when it comes to wills and trusts. What's the difference? Do you need one? Who needs one? So we're talking to Allison Kierman. She's an estate planning attorney, and she's out of Scottsdale, basically right down the street. How are you today, Allison?
Good, thank you.
Listen, let's talk about wills and trusts, and just give us a brief description between both of them. What is a will? What is a trust?
A will is a relatively simple document that says, when I pass, this is who gets what, and this is who is in charge. And if, like Susan, you have minor children, it also says who takes physical custody of your children and who takes control of the money while the children are younger. So it's really about who are your people, who are important in your life. A trust is more comprehensive. I joke a good will is going to run you 20 pages. A bad trust is going to run you 40 to 60, right? A trust is more comprehensive. It's like the business of your personal life. You are putting all of your assets into the trust, which really just means you're retitling them. And the trust says in very specific details, the who, what, and when. So who still gets what, really when, which means I don't want my 18-year-old getting my $1 million life insurance. I instead want my 18-year-old to get it in increments over time, to pay for school, maybe to get a house when they're older. And you're appointing someone to be very responsible with managing that money and distributing it over time.
So who actually needs a will? Who needs a trust? How do you determine which bucket you fall into?
So a will is the only place where you can name a guardian for a minor child. So if you have kids, at least under the age of 16, you should do a will. Whether you need a trust also really depends on your other family and your assets. So in Arizona, if you have good equity in your home, most people want a trust. A trust gives you additional protection. It prevents against deed fraud, but it also makes sure to preserve some of that equity. And that's a greater resource for a lot of people in Arizona. Go ahead.
So, and when you so you would have to put your home in the trust. So it would be like the Susan Campbell Trust, and that would be listed on the deed.
That's correct.
And then God forbid, if something happened and she's
no longer the host of this On Your Side podcast.
That will never happen. And if she has listed people to take out beneficiaries, then they will be able to take possession of the house.
Yes, would move into her home to continue raising her child until he is older.
Let's go back to the will. I'm not a big fan of the will because it has to go through what's called, as you know, probate court, and that really takes a long time. There's a judge that gets involved. It's very time consuming. Can you tell us how the will works and how it goes through the court system?
Yes. So I do view the difference between a will and trust as time and money now to set up the trust, or time and money later to take your will through probate. So Arizona has multiple levels and types of probate. It gets a little complicated. I would say the basics is you either don't have a will or you take a will to the judge in probate court and say, can I administer this deceased person's affairs? The downside of probate is you have to give notice to other family members, maybe people you aren't close to, maybe people you don't know where they live, and you have to give notice to all the creditors, right? So anybody who ever had a debt against that person's life is going to come collecting. And then you have to sort out what's a real debt and what's not, what has to be paid and what doesn't have to be paid. And that process takes a minimum of 9 months, but really most probates go 18 to 24 months and are going to run you, right, multiple thousands of dollars over the original cost of just doing an estate plan.
Oh my goodness.
Ouch.
So up to 2 years and money out of your pocket.
So let's talk. I mean, there is a push to at least get people to do a will especially if they have minor children. And there are tons of online options that, you can do a very quick will, just to put a couple things in writing. Does that option ever make sense?
It definitely can. I would say for things that are simple, for people who have simple lives, for people who really know what they're doing. So the example, though, I have is a woman did one of those online programs and passed away. And when her husband went to go back and look through things, all the documents say everything goes to her son. But he is still living. And he was the income earner. But because he didn't have a lot of time, his name actually wasn't on most of the accounts or on the house. So he lost most of his assets to her son. And he doesn't know if it was an intentional or not because you can't ask her anymore.
Oh.
And so the downside of the online programs is, do you really know what you're saying? And have you thought about the scenarios of who passes first or second or who's ill? Just those kind of nuances that come to play.
Holy moly.
I guess that was her son, not their son together?
That is correct.
Oh, boy.
What are some of the other giant mistakes that you see people making that we can try to avoid?
So I have somebody today, and dad's will left $3,000 to one daughter, $4,000 to the other daughter, and $1,500 to the two grandchildren. But it also says the $4,000 daughter's kids get her share if she's passed away. Which means I have to tell the woman today that she is getting $3,000, but her nephews are getting $4,500. This is actually per month, not a one-time lump sum. And in no world does she think that her dad would have given the grandchildren more money than they gave her. I think that was like an error, right? There's a sentence in there that was a form sentence, either that he got online or didn't talk about with the attorney, that is just a glaring difference between how much money the second and third generations will get. And again, this is monthly indefinitely. So we're talking about a lot of money that I think was a miss, just an error that we can't fix now.
That is, and you have to have that conversation with that person today.
Correct.
Oh, that's
brutal.
Boy, yeah. Good luck with that one. That's not good.
I should say I did not draft that plan. I'm just explaining that plan to
you did not make that mistake. There's a name for that too when somebody makes a mistake, isn't it?
Well, it can be called malpractice.
Oh, okay. Well, there we go.
She doesn't do that.
No. Let's clear the air here. That was not her mistake, and yeah. So let's move on.
Well, how often do you come across that where you have to flag what appears to be a giant mistake for people? I mean, are there mistakes in a lot of these estate plans?
First of all, it usually only comes to an attorney when there is a mistake. So that's not totally a fair question. Yes, I see a lot of mistakes. And I always feel bad where it's like, if you had called me 2 weeks ago, I could have solved this problem. But now I can't solve it.
Let me ask you this. When it comes to, say, a trust, and you have named the beneficiaries, and let's just say there's 5 kids, and those 5 kids don't get along, but you want one to be the executor. How is or you don't really want that person to be? Can you leave everything with the attorney and just have the attorney just disperse everything to the 5 kids?
You definitely can. Or not just the attorney, but you can get what's called a fiduciary. So someone whose job it is to administer the estate. And we often use that tool when there is fighting family. People all the time think someone is stealing money or being dishonest. And so if you use a third party neutral, right, someone without skin in the game, it just is much easier.
Yeah. And that's what you see on TV a lot when someone passes and they have the big
reading,
the big reading with all family members, and the dog gets
the whole thing,
the $2 million, and
kit and caboodle,
and nobody else gets anything else. Yeah, so you can have the attorney, probably the one that draws up the trust, to kind of be the executor.
You can.
So what are the actual pitfalls? Say somebody, a lot of people pass away without a will. What are the pitfalls of dying without a will? You don't have that many assets in life. Maybe you've rented your whole life, so you don't even have a home, and you don't ever think that this matters to you. What are the pitfalls of that still?
I want to be honest. If you don't own a home and you don't have a lot of assets, you might not need a will. Right? You could do what's called a beneficiary designation if you have financial accounts. And that's for simplified affairs, people who really just have one kid or no children at all. Right? The opposite big pitfall, though, I do see is when people do have a home and someone else lives in it. We do a lot of evictions in estate planning. Right? I see a lot of, mom told me the house was mine. Mom telling you something is not enforceable by a judge in a court in Arizona. So those are kind of some of the biggest issues that I see that lead to a lot of family fighting.
And you just brought up accounts, and that's really important. If you don't have a substantial amount of wealth, and let's just say you have maybe $6,000 left, but you do want to distribute that, but you don't really want to pay for a will or a trust, it's important to let your banker know that there should be like a POD, a pay on death, meaning if you pass, it should go to a beneficiary. That's a no-brainer.
Yes, you can actually do that with your car also in Arizona. So there are some techniques. Sometimes you have to pay for advice to know about them, but there are some cheaper techniques for people who don't have a lot or for people who just don't care.
How much does it cost to make a will or a trust?
That's a hard question in isolation. I would say good advice is going to run a single person $1,000 for things that aren't complicated, and around $4,000 to $7,000 for things that are more complicated, or if you have lots of children or lots of assets.
Yeah, a lot of assets, that could really drive up the cost.
How many times can you change it?
Indefinitely.
So we could be best friends. I could call you every single day and be like, I thought of something else.
That is true.
Hey,
really, you're calling me because you decide you don't like your brother anymore.
And you're also,
I love Joe.
And
he's okay with me.
You're also getting billed every time you want to talk to somebody like Allison. What else were we? Go ahead.
Well, I was just going to say, I have a funny story. So, speaking of children who gets the kids, we have a couple dear friends who had decided who would become their kids' guardians on the event of their untimely passing. And she said they were on this friend's vacation, and it suddenly clicked. They're flying over the ocean with the people who would be the guardians. And they're going, oh my gosh, we did not think through this. Like, all 4 of us are on this plane together, and our kids are all home with grandparents and oopsie daisies.
Oh, I hope they had a backup plan, so in case they're not available, it's going to go to these
and they
people.
had planned for what they thought they needed to, and it's always, you need a backup for the backup for the backup.
You do,
sometimes.
Yeah. It's like having a quarterback in the game. You got to have at least 3 backups.
The Browns are good at that.
Oh, you're right about that. Hey,
how many do we have? 6?
There's way too many. You can't even count them on your hand. Allison, there's some terminology with wills and trusts. One is like revocable, and then there's some other ones. What do they mean?
So a revocable trust can mean you can change it, or you and or your spouse can change it while you're living. So you could add children, take out children, assets, add assets, or take out assets. Irrevocable means you cannot change it anymore. Most people start revocable, meaning we're going to update this as our kids get older and as we age and as we're moving around or adding or subtracting businesses or homes. At some point, often after the passing of the first spouse, it becomes irrevocable. This is especially true in blended families, right? My wife and I agree, but when one of us passes, the surviving spouse cannot remove the other children, right? That's irrevocable at the passing of the first spouse.
Got it. Are you, for people who are married, do you have to have your spouse signing off on your will, or can you have your own individual will or trust? How does that work?
It depends on how the assets are. So I definitely have some people who are married and they have what we call sole and separate property trusts. A simple reason for this is you got an inheritance and you're supposed to protect it or you want to protect it just in case you get divorced. Some people have separate assets. They came to the relationship with separate assets. Maybe they have a pre or postnuptial agreement and they want to do it separate. And the third is for the couple who either can't agree or they don't want to do anything. So I have this client right now and we're doing his plan because his wife refuses to talk about the possibility of death. But he knows someone has to manage things if he can't. So he is taking care of her, even though she refuses to engage in the discussion.
Well, you bring up a good point because it is a hard conversation for some people. You know, like we can joke around about it right now, but when you're sitting down to talk about the nitty gritty and you are talking about, you know, somebody's end of life, it can be hard and you can understand why people kind of pull away from that conversation. How do you get around that with clients to make sure they are considering just facts and not throwing emotion into this?
It's hard. You have to be at a place where you're prepared, right? So I say, let's talk about who you like, right? Let's talk about who you don't like. I have a lot of very corny jokes. It's wonderful times here. You have to be prepared, though, to accept if something happens to you, it is more sad for the people you've left behind. So you don't want to think about not being here. But if I think about my kids with me not being here, I'm like, oh, we have to fix this now. Like I will stay up all night long working on things to make sure they never feel that emotion.
That's fair.
Yeah,
it's a good point.
You got to get it done. Hey, Allison, thanks so much for the conversation and, you know, educating us. I mean, it's very important to do. So even if you don't have a ton of money, I mean, you want it going somewhere and you want it going in the right places. Allison, if somebody wants to know more about you or your background or your office, where can they find you?
So I'm online. My website is Kierman Law, KIERMANLAW.com, or you can always call the office. I'm up here in North Scottsdale.
All right. Sounds good. Again, thanks for being on the On Your Side podcast. It was great seeing you, and we appreciate you being here.
Thank you so much. I appreciate you.
All right. It was great seeing Allison. And yeah, I think she probably opened up the eyes for a lot of people who maybe they've not been thinking about a will or a trust because, you know, people don't like thinking about passing away. Like you said, you don't want to put emotion into it, but you do want to make the right decisions so assets go in the right places.
It's just facts. I think that is helpful when you're starting the conversation, right? And I do think that because there are so many different options, it's just important to involve somebody who's an expert in that conversation. I don't know what I need. You know,
right.
you don't know what you don't know. So when you're working on this plan, get started with something and then tweak it as you go to make sure it fits the life that you have.
Right. That revocable trust that she was talking about, you can go back and change it as many times as you want, but it needs to be there. So, all right. Thank you, Susan.